Right. Good evening. Let's start. This session is, as always, being recorded and will be available on the website for a week. The other sessions have been taken off. So this is now replacing those sessions. And let's just start off. There are two matters that I want to discuss this evening. The first of them is really the most important, which is this TN on behalf of BN, which is a Supreme Court of Appeal judgment, a very important judgment, in fact, and one that came out a few days ago on the 11th of February, so sort of late-ish last week. The judgment dealt really with the well-known public healthcare defense, and it's the Supreme Court of Appeal that handed down that judgment. So it's well worth having a look at and considering more fully. And let me just share that with you, share the comments with you. Just give people a moment or two to catch up as well. So I'm going to just pull this up and give a minute or two. I know there are one or two people still coming on board. All right, let's start off with a media summary of this TN judgment. The media summaries are available on the Supreme Court of Appeal website. You'll see from this judgment, they are quite accurate and quite useful just in themselves. But there are one or two aspects of this judgment that I do want to accentuate, which aren't apparent from the media summary. But in any event, the Supreme Court of Appeal prepares this media summary. It's not prepared by myself, prepared by the court. And this is effectively a summary of the judgment. Today, that's the 11th of February 2026, the Supreme Court of Appeal, SCA, upheld an appeal, in other words, decided that the appellant in that matter was correct, so it upholds the appeal against the judgment of the Eastern Cape Division of the High Court Bishop, the High Court with costs, including the costs of two counsel. The matter arose from a claim for damages instituted on behalf of a minor child who suffered a catastrophic brain injury resulting in spastic quadriplegic cerebral palsy. So it's one of the CP cases. Those that practice within the medical negligence field will be very familiar with these cases. They are complicated, they're worth a lot of money, and they raise significant issues from time to time. And because there's money in it, there's enough reason to litigate these matters fully, and that's what happens very often and happened in this case as well. So it got up to the Supreme Court of Appeal as a consequence of the negligent management of labor and delivery at a public hospital under control of the member of the Executive Council for Health Eastern Cape, the MEC. Now, liability for negligence was conceded. So the question of negligence was not before the court, and the dispute before the High Court concerned the appropriate form of compensation for future medical care and related needs. The High Court, following a lengthy trial with extensive expert evidence, developed. Now, the High Court, in other words, what's happening here is that the Supreme Court of Appeal is a higher forum than the High Court. In other words, this comment now in this paragraph is referring to what happened previously in the matter, not what was decided by the Supreme Court of Appeal. The High Court, following a lengthy trial with extensive expert evidence, developed the common law governing damages for personal injury. It departed from the long-established once and for all rule, which requires that all damages, including future damages, be claimed in a single action and paid in a lump sum, the rule. In other words, what the High Court had done is there's always been, since time immemorial, an approach that where you claim damages, including future damages, this must be claimed in one action, in other words, in one case, and you've got your lump sum rule. In other words, everything must be claimed in one action. You don't have the chance to go back later. That has important implications for expert witnesses because everything needs to be calculated now, even future expenses. And that's why we get into these well-known calculations relating to the calculation of damages what would be appropriate in the circumstances of the case. All of those things come up both in respect of past and future medicals, because you can't come back in 20 years or 5 years' time and claim an additional amount. So that's the origin of the practice of calculating everything in one go. Instead, the High Court ordered that future medical care. So now the High Court departed from that principle and said, look, you don't have to claim everything in one action. And the High Court had said, in Eastern Cape High Court, said that future medical care can be provided through a combination of state-delivered healthcare services and undertakings by the MEC at her discretion to pay either. So what the High Court said is, instead of having to claim in one action, in one lump sum, future medical care can be provided by a combination of state-delivered health services. In other words, the state could then, instead of paying out as part of the lump sum, the state could then rather provide services, medical services, and undertakings by the MEC at her discretion. And the other thing was that the MEC could now make an undertaking whether to pay or to buy specific services effectively from the private sector. So quite an important departure from the general approach which was taken, or the standard approach that was taken up to that point where damages are claimed in one go. Now let's get to the appeal. The issue on appeal was whether this development of the common law. So what they're talking about is the common law had always said you claim a lump sum amount. Now what was happening is the defendant said, no, we should develop the common law. So you don't have to just pay a lump sum. The defendant can choose either provide those services herself, or can pay for the private sector at some future time to provide those services. And the issue on appeal was whether that change in the common law was constitutionally permissible. Don't worry about the sections of the Constitution. They're not really, the nitty-gritty isn't that relevant. And whether the High Court was justified in replacing a lump sum damages award with the so-called public healthcare and undertaking to pay remedies. In other words, that instead of paying a lump sum amount, the defendant will now pay, will either provide services or will pay for the remedies. The High Court's reasons for granting the remedies were, one, that the rule impedes the MEC in carrying out the obligation of realizing access to healthcare for everyone in terms of the Constitution, and that it does not provide fully for the child because more than 40% of the damages awarded is taken by lawyers as fees. So this question now of contingencies and payment and costs came into this case as well. The High Court stated that granting the remedies was an incremental development of the common law. And if you read the judgment, you'll see that why that's important is that the concept is that the common law, and when they talk about the common law, they're just talking about basically the law made by the judges, such as this case. This case is the common law. And for our purposes, we can differentiate it from acts of parliament. So this is not an act of parliament. This is a judgment by a judge, but it has the effect of law because it is a judgment. And then we loosely sort of refer to judge-made law as common law. There are some other meanings to common law as well, but that we don't have to concern ourselves with now. Just take on board that where they talk about the development of the common law, they're talking really about the development of the rules developed by the judges. And the idea is that the law must develop and must change and must keep up with the times. But the concept is to do that, what they say, incrementally, in other words, slowly. So it needs to be done step by step. And there shouldn't be a huge jump in the development of the law when you develop judge-made law. And one of the big questions that came up in this case is, well, should this law be developed by the judges or should it be developed by Parliament? We'll get into that in a few minutes' time. Now, the SCA disagreed with the High Court's approach. The SCA held that the High Court, SCA meaning Supreme Court of Appeal, in other words, the appeal court that sits in Bloemfontein and is now deciding whether the High Court got it right or not. It held that the High Court had radically restructured the law of damages. Okay, so now there's a radical, said, look, there's a radical restructure. The whole way in which damage is being approached in this country, where we get experts to calculate damages in future, We have to do actuarial calculations. We get industrial psychologists involved, all of those things. To restructure that disregarded the impact of its order on fundamental rights such as equality and dignity, created uncertainty and the prospect of ongoing litigation, and ignored its proper institutional role in the separation of powers. I just want to talk about the separation of powers. In other words, you have the courts, and you have Parliament, and then you have the executive, which basically implements what is decided by the courts and Parliament. And in this case, what the judges were saying is that there must be a proper distinction between what the courts do and what Parliament decides. And it then went on to say, Parliament, not the courts, the SCA emphasized, is responsible for major law reform, because future medical care commitments such as the remedies involve issues of social, economic, and financial policy. In other words, what they were saying is this now is a major change in the law. And the correct way to do that is to go through Parliament, not through the courts. And I will give you a quote as to why you don't go through the courts and rather through Parliament. The SCA found on the evidence it was irrational to conclude that the MEC would be able to provide lifelong future medical treatment for the child, or that future payments would reliably be made under the remedies. So what the Supreme Court of Appeal found was that on the evidence which was presented at the trial, the court could not say that the MEC would be able to provide lifelong future medical treatment for the child. In other words, this related now to how effective and efficient the delivery of medical treatment is in the public sector. The court said because the track record, particularly of this particular province, Eastern Cape, is poor, the court could not justify an approach that said that, well, we can guarantee that appropriate care would be provided in future. And so that weighed heavily with the court, because the MEC was trying to say, well, we will provide that health care. And the court said, but we can't accept that you can guarantee that that health care will be provided at an acceptable standard. Or that future payments would reliably be made under the remedies. So they went further, and they said not only could the courts not rely on the quality of health care being provided, but also the courts could not rely on future payments being guaranteed in terms of the remedies. In other words, remember that payment, that undertaking to pay in the private sector if necessary. The court said the evidence doesn't support getting that undertaking to pay. This shifted the risk of systemic failure by the Eastern Cape Department of Health from the wrongdoer to a profoundly vulnerable child. Consequently, the remedies do not ensure full and effective compensation to which the child is legally entitled. In other words, what the court was saying here is that now, instead of the Eastern Cape Department of Health undertaking the risk of a systemic failure, there's something goes wrong, that's the problem of the Eastern Cape Department of Health. Now suddenly you're making it the problem of a vulnerable child, because if something goes wrong, either from a financial perspective or from a healthcare delivery perspective, now the child that has been given has been successful and has got a court order, but has been told, look, the department will provide these services or they'll pay for these services. Suddenly that child, if the department collapses or if the quality of care is not sufficient, suddenly it's the risk of the child in terms of that court order. And that the Supreme Court of Appeal did not like that. And therefore, the court concluded that the remedies do not ensure full and effective compensation to which the child is legally entitled. And so here we have the problem where the court says, but the child is entitled to full compensation. And now it's not getting full compensation in terms of that order. And so the SCA concluded that the High Court's development of the common law, because attorneys were taking the bulk of damages awards as fees, is a misdirection. It now considered remember the other aspect that came up is the question of attorneys' fees. And in terms of the current system, as we know, attorneys take a fair percentage of those fees, 25% in terms of the Contingency Fees Act. And the court said that but you couldn't say that because attorneys were taking up to 40% of payments, that was a valid reason not to allow the current system to remain in place. And it held that misconduct by legal practitioners in relation to lump sum awards must be regulated by legal professional bodies such as the Legal Practice Council. So what the court was saying is, look, we've got a system in place. It's regulated in terms of Contingency Fees Act, and we are going to, and that's the appropriate way to deal with any queries or issues that arise around how much attorneys get paid and the whole cost system around damages. The SCA concluded that the High Court's development of the common law, because attorneys were taking the, sorry, I beg your pardon, I've been through that. Then accordingly, the SCA set aside the High Court's order. So the SCA said the High Court's order no longer stands and replaced it with an order restoring a conventional damages framework. In other words, the way it was always done, it replaced the new type of order with the public health care provisions and went back to the previous system, which we all know so well, which is a lump sum award for agreed future medical and related care, provision for professional caregiving, therapy, assistive devices, transport, and case management. The matter was remitted to the High Court for the determination of outstanding quantum issues and for the establishment of a trust to administer the damages awarded on behalf of the minor child. In other words, that portion, those questions were then sent back to the High Court, and some issues relating to quantum went back to the High Court. So in summary, what happened in this case is that the Supreme Court of Appeal found that the existing system of the payment of a lump sum is preferable to a system of getting the same Department of Health to provide healthcare in circumstances where something has gone wrong. It didn't follow the line of argument put up by the defendant, by the Department of Health, that this was a threat, an existential threat from a budgetary point of view. And one of the points the Supreme Court of Appeal made is that it's for the department to sort out its own standards of healthcare and not allow negligence and therefore claims to arise. And so that would be the more effective way of dealing with claims of this nature and reducing the huge liabilities which the Department of Health has in this regard. So that basically is TN's case, and what it means is that the way that we approach damages, the future quantification of damages and the like, is now, in terms of the Supreme Court of Appeal, is now no longer, there will not be any changes in terms of this judgment. This judgment, I'm quite sure, will go to the Constitutional Court. So similar to the past medical expenses judgment that we looked at last week, this judgment will go to the Constitutional Court, and let us see what the Constitutional Court has to say about the reasoning of the Supreme Court of Appeal, where this issue will finally be decided, sort of, and to excuse the pun, but will be once and for all, will be decided. Okay, so that's TN's case, and then I just want to have a quick look at the other matter, the other case that I said that we would have a look at. You remember last week I'd said that we would look at this one, and that is the I had it up on screen. There it is. Yeah. So Holtzhauzen versus Roodt, and I'm not going to go through this in very much detail, but effectively what Holtzhauzen versus Roodt, quite an interesting case. In this case, the plaintiff sued the defendant for defamation arising from reports which the defendant had made to her mother and allegedly her close friend and sisters. The statements consisted of the defendant alleging that she'd been raped by the plaintiff. So a woman alleged that a man had raped her. Much of the evidence in the trial was directed towards ascertaining whether or not the defendant was indeed raped by the plaintiff. And then what happened is a very unusual set of facts. The defendant gave notice in terms of Rule 36(9) of the Uniform Rules of Court of her intention to call 2 expert witnesses. The plaintiff objected to the admissibility of the evidence of those witnesses. The first witness held a degree in clinical psychology from UNISA, was qualified as a clinical psychologist and registered as such with the then South African Medical and Dental Council. Those who've been around for a while remember the SAMDC, which preceded the HPCSA. He was also a member of the South African Society of Clinical Hypnosis. Now, this is where the case takes an interesting turn. It was intended that the witness would state that hypnosis is a way of accessing subconscious memories and thoughts from patients by inducing in them a state of trance and or deep relaxation. The witness would also have stated that hypnosis was used to help patients come to terms with unhealed emotional and mental scars. The witness consulted with the defendant on a number of occasions, and the witness was told by the defendant that she had been raped by the plaintiff. The witness induced a state of trance in the defendant. So now this so-called expert, who is allegedly an expert in hypnosis, was now going to testify that the witness induced a state of trance in the defendant in which she recalled the incident. So it would be very, very important evidence, because if this evidence was admitted, then it would obviously be evidence that the rape had in fact occurred. And, you know, of course, the question of whether the woman was raped or not was critical to the outcome of the case. So in short, what was happening here is that there was an attempt to introduce so-called expert evidence on hypnosis. And now the question before the court was whether that evidence should be admitted as expert evidence. Then we saw that there were two experts that were to be called. The other witness, which was sought to be called, held an undergraduate degree from the University of St. Lawrence, in which she majored in psychology. She held a master's degree in social work from the University of Wisconsin. She was the clinical supervisor of POWER, People Opposing Women Abuse, which includes the counseling of women who've been raped and or are in abusive relationships. The evidence sought to be led was to the effect that the witness had attained the necessary experience. So now this is where they're saying, all right, this is why this is an expert, because this witness has attained the necessary experience to state that women who have been raped and or sexually abused very often do not immediately relate the rape incident to third parties. Very important evidence. You know, when you deal with rape cases, there used to be an old principle called the raising the hue and cry. It's an old English expression, the hue and cry, which is that it was kind of expected of the woman, if she's been raped, that the reasoning there was that if a woman was raped, you'd expect that she'd immediately raise the hue and cry and start shouting it out and sort of almost alerting the community to the fact that she'd been raped. Now, this particular case, I don't think that principle of the hue and cry I don't think it was mentioned in the judgment from my recollection, but that does come up when you deal with rape cases. There's this kind of thinking that the woman, if she had been raped, why did she wait 2 weeks, or why did she wait a year before she reported this rape? Now here we had what was suggested to be an expert who dealt a lot with rape survivors, and this expert was going to say that she had attained the necessary experience to state that women who have been raped and or sexually abused very often do not immediately relate the rape incident to third parties. So very important evidence. And in this case, I don't know the facts here, didn't emerge fully from the summary, but here there must have been a delay in the report of the rape. It was further her experience that victims keep incidents of rape and or sexual abuse to themselves for long periods of time before confiding in others. So again, very important factual evidence, but now they're saying this is expert evidence because this particular person is qualified by virtue of her experience to assist the court in assessing a factual situation. And you'll remember that we had a look at this concept of, well, what is an expert? And an expert must be one who is able to provide appreciable assistance to the court. And so the question is, there are two witnesses. There's the hypnosis witness, and now the witness has experience of rape survivors and rape situations. And the question is, should that evidence be admitted as expert? Now we come to the court's finding. The court was of the view that the evidence of the first witness was not relevant. In other words, the hypnosis, the suggested expert on hypnosis. The court said that evidence would not be relevant. Why not? The court held that it was its duty to make certain determination on its own, on an assessment and on evaluation of all the evidence that was placed before the court, and not just on the version as presented by the defendant. In other words, what the court was saying is, it's not relevant what the defendant's view of what happened is. It's the court's duty to go through the evidence and decide whether this rape occurred or not. Regarding the first expert witness, that's the hypnosis expert, the court held that the view that hypnosis would be a more accurate method of determining the truthfulness of a witness's statements was a test allegedly verging on the infallible, and that to accept such evidence would usurp the function of the court. Each potential witness could then be placed under hypnosis and a prepared set of questions put to them through the hypnotist, with the expert subsequently testifying as to the results. The court rejected this approach. In other words, the court said that it was not going to allow a situation where you take a person who's got an incident that's alleged to have happened, put that person under hypnosis, and now the hypnotist then comes to court and says, well, this is what the person said happened, instead of the process of testifying in the witness box, getting cross-examined, etc. So the court therefore said that particular witness was not an expert because it couldn't provide, the witness could not provide appreciable assistance to the court because the court needed to decide whether this rape happened or not for itself. And so the views of that expert were therefore found to be irrelevant. But regarding the second witness, the court was satisfied that she did indeed qualify as an expert on the subject of abuse and rape of women. However, the objection to her evidence was that her remarks were of a general nature, that she had no personal consultation or discussion with the defendant and was unable to testify about the defendant herself. It was also argued that the relevance of her evidence was questionable. I'll come back to this and explain it. The court held that in respect to the evidence of the second expert witness, due to the limited experience which judicial officers have on the subject of rape, it would be unwise and irresponsible for the judge, who was lacking in such special knowledge and skill, to attempt to draw inferences from facts which have been established by evidence without welcoming the opportunity to learn and to receive guidance from an expert who is better qualified than the judge to draw inferences which the judge would be required to draw. Then isn't that really the classic situation of when the court requires the evidence of an expert witness? Where, remember, it's that concept of this person, by virtue of their training, skill, and experience, is in a position to provide appreciable help to the court. And here the court said is a very good example of that. The court doesn't have this experience of rape survivors. Here we have an expert who can tell us about the experience of rape survivors. It would be unwise, was the word used by the court, not to accept that evidence. The guidance and opinion of the expert witness would merely be one pointer for the assistance of the court. In other words, this was different now in this respect to the hypnotist type evidence, because now it was a situation where the court was saying the expert's views were not going to replace the proper judicial process of running a trial and having evidence tested through the trial process. Here, the expert evidence on this person who had the evidence of rape survivors was just going to be one factor which the court would take into account. In other words, the fact that generally survivors of rape may not report that rape for some time would be a fact that the court could take into account, but would still weigh up the credibility and the cogency of the evidence which was led in that particular case. The court, in other words, may still have found that even though this particular person delayed their report, and even though that does often happen with rape survivors, nonetheless, the court would then still assess that person's version and decide whether the court believed that the rape had happened or not. And so then that was still a proper functioning of the court process. Accordingly, the evidence of the expert was allowed, and she was declared to be admissible as an expert witness. And then the court went on to deal with the nature of expert evidence, and there are various factors. I'm not going to go through that. Those that have got the book can go and have a look further at that. And it's also dealt with in the intermediate expert training module. And so that really concludes this portion of the tutorial this evening. Just to again emphasize that we are now bringing a vocational training program for expert witnesses. If you want to be properly trained in how to provide expert evidence in the High Court. We put that course together. That course we are busy rolling that course out at the moment, and it will start getting momentum this week. That course will consist of the introductory level, intermediate level, and advanced level. The information is on the website, and we will also put information up on the WhatsApp group from time to time. So just to summarize, two very interesting cases. The TN judgment, very, very interesting judgment with far-reaching implications for how the courts approach the assessment of damages, and in particular, whether the once and for all rule applies. Now, for any expert that's involved in assessing future damages, that can have profound implications, because if that judgment goes the other way, then the question then arises as well, would there be a need for future damages, assessment of future damages? How would it impact it? It wouldn't be as dramatic as there just wouldn't be any more cases, but it would have an effect on how that particular process works, and would, of course, affect people's practices in the long run. So TN's case has been decided. The Supreme Court of Appeal has decided that things will stay as they are. We will have to see what happens with the Constitutional Court, but that's the latest judgment on this important topic. And then the Holtzhauzen versus Roodt, I like that judgment. It's a very unusual judgment. It's memorable, so it sticks in the mind. And I think it's actually a very nice demonstration of how the principles relating to the admissibility of expert evidence operate in practice, and the proper application. I think the court got it right in respect to both witnesses. So quite a nice practical example of those principles. All right, thank you very much for watching the tutorial. I tried to keep them to half an hour, 45 minutes. We try and sometimes have a more complicated matter that comes up like last week, but these two this week, we could get to the essence of it. And I will see you. I'm not sure what the program is. I think it's next week again. And then we will then continue, but we will place alerts on the group. Thank you very much for your time, and I hope to see you soon. Cheers, and bye-bye.